You're listening to Simply Put, a podcast from FHN Financial. I'm your host, Will Compertall. The U.S. Court of International Trade ruled last month that President Trump's new tariffs were outside the lawful scope of the executive's emergency powers, complicating ongoing trade negotiations and adding to an already uncertain policy landscape. Professor Ilya Somin of George Mason University was a co-counsel on that case, arguing on behalf of a few small businesses that were negatively impacted by the new trade levies, which remain in effect for now as the case works its way through the appeals process. On today's episode, Professor Somin talks to us about the legal paths for implementing tariffs, why the Court of International Trade ruled in favor of these businesses, and what the White House is likely to argue on appeal. Stay tuned. Coming up soon, our interview with Ilya Somin, but first, a quick market update. The conflict between Israel and Iran appears to have subsided for now with a fragile ceasefire. WTI crude oil had climbed as high as $75.14 per barrel last week, but has since fallen closer to $65 per barrel. Financial markets were on edge after the U.S. launched 3 missiles at Iranian nuclear facilities last weekend, but the Iranian response was tepid enough to convince investors there is a relatively low risk of further escalation. The Fed left its key policy rates unchanged last week, as expected. While the median FOMC participant still projects 2 cuts this year, the dot plot shows the FOMC has broadly separated into 2 camps: those who feel the need to wait to see tariff impacts on inflation, and those who feel confident moving forward with rate cuts soon. The Treasury market response was fairly muted, in part because Chair Powell emphasized such a low amount of conviction within the FOMC regarding the outlook. There were also a couple notable appearances from Fed officials after the meeting. Fed Governor Michelle Bowman, a longtime policy hawk, said the data could permit the Fed to cut rates as soon as the July meeting. Governor Chris Waller, too, introduced the possibility. Treasuries rallied after Bowman's speech, and Fed funds futures pushed up the next fully priced-in rate cut from October to September. The Treasury curve bull steepened over the last 2 weeks, driven by safe haven flows and slightly higher optimism for rate cuts this year. Yields on 10-year Treasuries are at the lower end of their 30-day ranges, near 4.25%. This year's big fiscal package has moved closer to the finish line after Senate Republicans made changes to the House-approved budget bill. With slim majorities in both halls of Congress for Republicans and strong disagreements between the GOP's fiscal hawks and moderates, there's no guarantee the bill will pass in its existing form. Treasury Secretary Scott Bessent and Speaker of the House Mike Johnson remain optimistic they will get something to the president's desk by their self-imposed July 4th deadline. That's all for the market update this time. Now our interview with Ilya Somin. Our guest today is Ilya Somin, professor of law at George Mason University, Simon Chair in Constitutional Studies at the Cato Institute, and a co-counsel on the recent court case that ruled this year's new tariffs illegal. Ilya, thanks for coming on the podcast.
Thank you very much for having me.
Our topic today is the legal landscape around tariffs. Who gets to decide trade levies under U.S. law, and whether recent court challenges could permanently undo the newest trade policies implemented earlier this year. Ilya, before we go into the specifics of the case currently working its way through the legal system, I think it's helpful to understand what the law actually says. So let's go way back to the late 18th century. Does the Constitution have anything to say specifically about who gets to implement tariffs?
Yes, it most definitely does. And Article 1 of the Constitution specifically says that duties and imposts, which are synonyms for tariffs, that their imposition is a power of Congress.
Now, Congress did eventually pass legislation saying the president can unilaterally enact tariffs using emergency powers. Can you tell us about those laws, what they say about the appropriate circumstances for when the president is allowed to implement tariffs?
Actually, the law in question does not mention tariffs at all. And one of our arguments is that there is no tariff authority under this law whatsoever. However, if you assume that there is tariff authority still, this law, the International Emergency Economic Powers Act of 1977, can only be used if there is 1, a national emergency, and 2, that national emergency is with respect to something that's an extraordinary and unusual threat to U.S. national security or to the U.S. economy. And none of those things are present here.
Now, so have these powers under that law, even if not for tariffs, been used before? So you say it's not been used for tariffs, but how were the 2018 tariffs enacted, which is, as far as I'm aware, were not challenged or overturned in the courts?
They were enacted under a different, narrower set of laws, such as Section 232, where you have to go through special procedures and findings. And at the very least, you cannot just simply start a worldwide trade war anytime you want, which is what the administration is trying to do here.
So I do get why emergency powers exist for mayors, governors, the president under the law. If a natural disaster just happened, you don't want to wait for the legislature to convene before you can unlock funding or other resources. But I imagine there are also some guardrails that prevent the president from declaring anything an emergency. So this Emergency Powers Act that we're talking about, that doesn't specifically include tariffs in its language. What does that law say about the kind of oversight from the legislature or judicial branch, how they can enforce these emergency powers?
So obviously, Congress can hold hearings after the fact and in principle repeal the national emergency that's been declared or repeal measures that have been imposed, though that would be subject to the president's veto. So in practice, it is often almost impossible to do. We contend also that it's not up to the president to just decide unilaterally that an emergency is whatever he says it is, or that an extraordinary and unusual threat is whatever he says it is. Rather, courts get to consider whether there is an actual state of affairs that amounts to an emergency and an extraordinary and unusual threat. In addition, the statute says that any measures taken under it have to deal with the threat and cannot do anything else. And so there is also an issue of, even if there is an emergency, there is an extraordinary and unusual threat, there is a question about whether the tariffs or whatever other measures the government takes actually are dealing with the threat, as opposed to using the threat as a pretext to do something else.
Yeah, I imagine, I mean, it would be quite foolish to write a law that does not provide any oversight, because if the president just says, well, it's an emergency, it's Tuesday, and so now I can do whatever I want, that's not really the best thing. But the law that the president has implemented these tariffs under, what are examples, either within the law or in past use, that are an appropriate use of the emergency powers, if not through tariffs? What is an economic emergency that you think they were getting at in the law?
There could be various things. One is, for instance, some kind of sudden economic crisis, like the balance of payments crisis of the early 1970s or the Great Depression. Another, is a sort of national security threat. For instance, in the past, IEEPA has been used to impose sanctions on Iran after the Iran hostage crisis, or to impose sanctions on communist Nicaragua during the 1980s, when Nicaragua was supporting terrorist groups in Central America and perhaps elsewhere.
When we read in the news that the U.S. government has implemented sanctions on foreign countries, is this under the same statute, or is it Congress that tends to do that?
Some of both. There are different kinds of sanctions imposed on different countries with different sets of laws. What this law does not do is allow for the imposition of tariffs or even other sanctions in an unlimited way anytime the president feels like it.
Let's move on now to the big court ruling that happened in May. First of all, what is the U.S. Court of International Trade? How does that fit into our legal system?
So the U.S. Court of International Trade is exactly what it sounds like. It's a specialized court which hears cases related to federal laws that provide for tariffs and sometimes other kinds of trade regulations. And with respect to those kind of laws, it serves the same sort of function that in regular cases would be served by a U.S. district court. That is, it serves as the trial court where people initially file their cases.
So tell us more about this specific case. Who were the plaintiffs and what was their complaint arguing?
So our plaintiffs, and I'm working this case with the Liberty Justice Center, which is a public interest law group. Our clients are 5 U.S. small businesses which import from the countries affected by Trump's so-called Liberation Day tariffs, where he's trying to use IEEPA, the law we talked about earlier, to impose 10% tariffs on virtually every nation in the world, and then additional tariffs on another 50 some odd nations. And our clients are severely hurt by this because many products and inputs that they buy are now vastly more expensive than they would be otherwise. That hurts their business model, undermines relationships with suppliers and customers and so on. And so, we recruited them and they were happy to participate in this case because this is severely damaging them. And we presented the case in the U.S. Court of International Trade, which we thought had jurisdiction. And we argued that these tariffs are illegal for a wide range of reasons. We've already touched on some of them. The statute doesn't provide for tariffs. There's no actual national emergency here because the claim rationale here is that there are trade deficits. Trade deficits are perfectly normal. They're not an emergency. They're not even harmful. And they're certainly, and that's the next argument, they're not an extraordinary and unusual threat because there's nothing extraordinary or unusual about them. The administration itself admits the trade deficit existed for many decades. And also, they're not a threat even at all. I have a huge trade deficit with my local supermarket. I buy a lot of things from them. They virtually never buy anything from me, but it's not an emergency or unusual or extraordinary or a threat. It's perfectly fine. It just means that I value the goods that I buy at the supermarket more than I value the money. And the same thing if we happen to buy more from, say, Canada than they buy from us. We value the products they sell us more than we value the money. And often it's efficient to buy things that they can produce more easily or more cheaply or better than we can, rather than try to make every single thing ourselves. Just like it makes sense for me to buy a lot of my food at the supermarket as opposed to opening up a farm in my backyard or buying my own herd of cattle so I can make my own hamburgers without having to buy meat elsewhere. It's the same sort of thing. On top of that, we have additional arguments. I can go through them if you're interested.
Sure. Well, before we go on to those other arguments, I wonder if the way that the law is written or what the opposition may have argued was, well, it's not up to you and me or even the public to decide what is an extraordinary emergency. Is this a proper and effective action? We elected the president, and the president is the one who decides what is an emergency.
So that is what they're saying, but nothing in the law says that. And as a general rule, it is the court's job, not the president's, to determine, how a law applies to a given circumstance. Moreover, and this gets into our other argument, if the president has the power to decide what an emergency is and also what an extraordinary and unusual threat is, then those terms in the law become basically superfluous. The law might as well just say the president can do whatever he feels like with respect to tariffs. And if that were the case, you run into the constitutional principle of non-delegation, which says that there are at least some limits to how much legislative power Congress can delegate to the executive. And if there are any limits at all, an unlimited power to impose any tariffs he wants on any nation in the world for any reason for as long as he wants, that surely violates non-delegation, if anything does, because we're talking about something like $2 trillion of new taxes imposed on Americans, damage to the world economy, price increases for consumers. If that power can be delegated to the president without limit, there's no other meaningful constraint either. Furthermore, the Supreme Court has enunciated over, particularly in recent years, the major questions doctrine, which says that when the executive claims that the authority to determine some major political or economic issue has been delegated to it, at the very least, that has to be clearly stated on the face of the statute. And nothing even remotely like that is clearly stated here. It's not even clear that you can use tariffs at all under this law. It's certainly not clear that the president can just decide for himself what counts as an emergency or an extraordinary unusual threat. And if there is uncertainty, then under the major questions doctrine, courts are supposed to reject the position of the executive. And on most of the points that I just mentioned, the Court of International Trade did in fact rule in our favor in a 3-0 vote in a panel that included both Republican and Democratic appointees, including one judge appointed by President Trump.
You mentioned that there were some other arguments that you made on behalf of your plaintiffs. Did you want to get into those just briefly?
Sure. I just mentioned 2 of them. One is non-delegation. The other is the major questions doctrine. Our 6th and so far final argument is the argument that there's a technical doctrine called constitutional avoidance, which says that if an interpretation of a federal statute is likely to raise constitutional problems, then the court should interpret it in such a way so as to avoid those problems if at all possible. And here, there's an obvious constitutional problem if you interpret this the way the government wants, as an unlimited grant of powers to the president to impose tariffs anytime he wants. And that problem can be avoided simply by saying this statute doesn't allow for tariffs at all, or by accepting any one of our other arguments, such as that there's not an emergency here, there's not an extraordinary unusual threat, the major questions doctrine compels a decision in our favor, and so on. Any one of those or some combination of those would avoid the constitutional problem. And under that doctrine, courts are supposed to avoid the problem if they at all can.
So Republicans are in control of the White House and both halls of Congress with slim majorities. If they did want to implement these tariffs, what is the legal way to do it if not by executive authority?
So Congress could pass a law saying that, we're going to have massive new tariffs and start a trade war with the whole world. Indeed, the last time we had tariff rates this high under the Smoot-Hawley Act, which helped cause the Great Depression, that's what Congress did. That was a terrible law that caused enormous harm, but at least it was passed in accordance with the constitutional separation of powers. Smoot and Hawley were actually members of Congress who passed actual legislation and didn't simply, the president didn't just simply do it as a power grab or try to make use of some law which gave him absolute and total discretion. Here, they're trying to do what is essentially a new Smoot-Hawley Act, a new massive disaster for the world economy, but claiming that the president has, unconstrained unilateral authority to do this.
So if U.S. officials really did want to negotiate different trade deals with every other foreign country, of course, it's very helpful to have it centralized. The delegation is just a few U.S. trade officials, and it's really difficult for Congress to come to an agreement to do that with all, just under 200 countries in the world. Is that just by design? I mean, how would that really be done? It seems like this is like negotiating a treaty where maybe we want to send a small group that acts on behalf of the U.S. government, or really is the only way to do this through Congress?
So the Constitution sets out a procedure for treaties, which is that the president can negotiate them, and then the Senate gets to ratify and must ratify by a 2/3 vote. Alternatively, there is the mechanism of the so-called congressional executive agreement, where the president can negotiate an agreement and Congress can enact it as a regular law, which is the way the NAFTA treaty and WTO, for example, were done. And I would add also that this administration does not actually intend to negotiate somehow to reduce trade barriers overall. They have repeatedly stated that at the very least they want to keep the minimal 10% tariff imposed in almost every country in the world. That itself is actually much more harmful and much worse than the pre-existing status quo. So rather than these kinds of negotiations, it would be better to just do nothing.
What happens next in the legal process? I'm sure the Trump administration is not going to just accept this defeat. So what does the appeals process look like?
The case is currently before the U.S. Court of Appeals for the Federal Circuit, which is the appellate court that has jurisdiction over the U.S. Court of International Trade. For the moment, the lower court judgment in our favor has been stayed while the appellate court considers the issue. There's going to be oral argument on July 31st in our case, and I expect that within a few weeks of that, or maybe a little sooner, we will have a decision from the Federal Circuit.
And now remind those of us who are not in the legal universe in our day-to-day life, when there is an appeal, what happens? Does there have to be grounds for an appeal? What is the Trump administration saying is the reason for this? Are they just looking for a new set of judges to come to a different conclusion?
So obviously the basis for an appeal is some kind of argument that the lower court got the decision wrong, and the ultimate basis for their appeal is simply the kind of argument that we talked about earlier, that they believe that this statute does in fact grant the president virtually unlimited authority, and they also claim that it would not be unconstitutional for that kind of unlimited authority to be granted.
Is there a pretty good chance that this goes to the Supreme Court like a lot of high-profile things that we've seen in the last, decade? Is it even possible that it skips appeals courts? How does that work? It seems like the Trump administration is going to exhaust all of their legal possibilities.
Whoever loses in the federal circuit, it is extremely likely that they will appeal to the Supreme Court. The Supreme Court will then get to decide whether they want to hear the case or not, with extremely rare exceptions that probably don't apply here. the Supreme Court only takes those cases that they want to take. Therefore, it would be up to them to decide if they want to take this one. I will only say that I think it has a higher chance than normal of being taken by the Supreme Court because of the importance of the issues, but they do accept only about 60 to 80 cases a year under regular docket. And obviously, there's thousands of petitions filed before them every year. So it's always difficult to get a case before them, but this case likely has a significantly better chance than normal.
We've talked a lot about the weaknesses in the law that they used for this unilateral executive implementation. Is there a more plausible legal path for the White House to enact these desired tariffs? I feel like when I am reading legal commentary casually, there seems to be an understanding, even among those who are very against these tariffs, that, well, they could get these tariffs done. They just need to do it in a different way.
My answer to this is that short of actually getting Congress to enact a new law, I do not believe they can do massive tariffs on this scale, against virtually the entire world by another path. It's possible they can do some more limited tariffs by another path, and you would have to see exactly how they do it and what arguments they make when and if they try it.
It is interesting, even with all the analysis and commentary on the big fiscal package this year, no one is saying, hey, Congress, why don't you take the tariffs up because that's actually your constitutional duty. I want to end then with just a question about your prediction of how this ends up. What do you think the probability is that the Supreme Court allows the executive branch to go ahead with this implementation?
So I obviously cannot know for sure, and I cannot give you like a precise percentage estimate, like 62% or something. What I can say is that we are guardedly optimistic that appellate court judges, potentially up to the Supreme Court, will see what the judges in the CIT, the Court of International Trade, saw, which is that there is just no basis for this kind of virtually unlimited presidential power over tariffs. It's a massive usurpation of authority. It's not allowed under the IEEPA statute. And we have 6 different reasons why this is illegal. For us to win, they only have to give us one.
Ilya Somin, thanks for coming on the podcast.
Thank you so much for having me.
That was Ilya Somin, professor of law at George Mason University. Ilya makes some convincing arguments for this year's tariffs being declared unlawful. But what I think is clear is that no matter how the appeals process ends up, tariff uncertainty is going to linger for the foreseeable future. The White House will keep pursuing different paths to implement tariffs, or lawsuits will keep challenging their legal standing. All the while, households and businesses will have to decide whether they pause their spending decisions or reorganize how they interact with foreign firms. Persistent paralysis could lower spending in the economy enough to cause significant deterioration in growth. Speaking of tariffs, the July 9th deadline after President Trump's April 9th tariff pause is fast approaching. With most bilateral agreements still up in the air, it's unclear whether the pause will be extended or there will be some placeholder tariff rates while trade deals are finalized. Next week, the May JOLTS, June ISMs, and June ADP will set the market tone before the June non-farm payrolls report on Thursday. The labor market has been resilient through policy shocks so far, but investors are on edge to see whether uncertainty and pessimism have channeled through to real economic activity. The consensus expectation is for a continued slowdown in payrolls growth and the unemployment rate to increase 0.1% to 4.3%. Public comments from Fed officials will become increasingly important over the next few weeks as investors look to see if new data cause any turning point in sentiment within the FOMC. Chair Powell and others are scheduled to speak, and we expect more appearances will pop up as time goes on. On Wednesday the 10th, the Fed will release the minutes from this month's meeting, potentially shedding more light on the thinking behind the divergent dots in the latest SEP. That's all for today's episode. Thanks again for listening. I'm Will Compertall, macro strategist with FHN Financial. This episode was edited by Bill Stanfield. Don't forget to like and subscribe to Simply Put wherever you get your podcasts. Email simplyput@fhnfinancial.com with any questions or comments. This podcast is presented for informational purposes only and is not intended as an offer or solicitation with respect to the purchase or sale of any security. Views expressed herein accurately reflect the speaker's personal views about the data, news, trends, events, etc. discussed herein or any subject securities or issuers. No part of their compensation was, is, or will be, directly or indirectly, related to any specific recommendations or views expressed. FHN Financial, through First Horizon Bank or its affiliates, offers investment products and services. Investment products are not FDIC insured, have no bank guarantee, and may lose value.